Good morning again. For anyone that missed my name, I'm Katherine Sandoval. I'm the managing partner in our California office of Matthiesen, Wickert Lehrer. So this is going to be an overview covering many topics about subrogation, debt collection, and consumer protection, and how it all applies. I'm going to be talking about the FDCPA, generally, and some of the other similar consumer protection laws in a couple of states that have stepped out in this area as it applies to subrogation. I also will be talking about how judges, and in some cases actually attorney generals, have attempted to fit subrogation into these particular boxes. So a little bit about my background. Prior to getting into the subrogation field, I was in the consumer protection field and FDCPA field. I actually represented debtors and I went against creditors both in state and federal court out here in California for violating the Rosenthal Act, which is the FDCPA, but at the state level in California. So this is actually a very familiar subject topic for me. So what is the purpose of the FDCPA? So the purpose is to eliminate abusive debt collection practices by debt collectors to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action to protect consumers against debt collection abuses. So what are we talking about? We're talking about what are the abusive practices, who are considered debt collectors, and it will require a consumer transaction. And we're going to see how this all fits into subrogation. So consumer debt. Debt is any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. So this is what makes it a consumer transaction. You're talking about if you borrowed money or if you purchased a piece of property. It could be an automobile, services like working on a car. Primarily, we're going to be talking about insurance, and that being specifically named created one of the opportunities for the federal government to kind of step in and be able to try to fit subrogation into their rubric here. Then there's also the personal and family and household transactions. I want to make a note that a consumer debt that is reduced to a judgment still falls under the FDCPA. So conceivably, if you had something in the subrogation context and you had a default judgment and obtained that default judgment, those activities still could be covered under the FDCPA. So what is a debt collector? A debt collector is any person who uses an instrumentality of interstate commerce or mails in any business of the principal purpose of which is the collection of debts, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due by another. So this is what, sorry. So let me just say that the FDCPA relies heavily on a series of definitions. And one of the most important is going to be the definition of a debt collector and who is considered a debt collector. And I say this because the FDCPA only applies to debt collectors. Now I say this, but I want to make sure you guys understand as well that in state law consumer protections, this definition is going to change. And we're going to talk about that shortly. But I'm going to stick to FDCPA. And I want to talk about some exceptions that the FDCPA has evolved for the debt collector. So a debt collector does not include any officer or employee of a creditor while in the name of the creditor collecting debts for such creditor, which in this case, if you're talking about a subrogated party, might be the in-house subrogation personnel at an insurance company or a health carrier. As far as who would be in the subrogation department, their activities as in sending demands or notices generally are not going to fall under the purposes of this act. The second one, though, which is slightly more confusing, is any person collecting or attempting to collect any debt owed or due or asserted to be owed or due another to the extent such activity concerns a debt which was not in default at the time it was obtained by such person. They always make these definitions so convoluted. So if you get a particular file, just in the general sense, not even in subrogation, prior to the time that the money is owed or it's not in default, those activities, even after it goes into default, are not going to be applicable. So lawyers as debt collectors. It's important to note that attorneys are not exempt from the FDCPA. They used to be, but one of those amendments in the late 90s removed that exception. So one thing to remember is that you don't have to be a debt collection attorney in order for the act to govern the activities. So again, I want to repeat that because that can be a little bit of a blurred line. You don't have to be a debt collection attorney in order for that act to govern. And there are two approaches to this. There's going to be the frequency, which requires only steady collection of debts, regardless of whether it is a substantial portion of the attorney or firm's business. So they're only looking for a steady collection effort. So in the case of Silva versus Mid-Atlantic Management Corp, this particular law firm only had 10 cases per year that they would be able to handle on debt collection. In fact, it wound up actually only being 1% of their entire business. But the court still held that that was steady collection of debt and counted it as debt collection as per the act. The other theory is the aggregate theory. It takes a broader approach and, in my opinion, the more reasonable theory. So it looks to the percentage of the alleged debt collector's business. So in that case, it was the Schroyer versus Frankel case. The debt collection was only about 2% of the firm's overall practice. They had no full-time person working on debt collection, and it was only 7.4% of their annual cases at around the time that this decision was rendered. So the court stated, well, it didn't apply. So we're at our first polling question. Attorneys are not exempt from the FDCPA. True or false? I'll give you guys a little bit of time to answer. Okay, I've got about 90% of the vote in, and 85% of you said true, which is correct. So requirements and prohibited practices. I should note that as we go through these requirements and prohibited practices and these abusive practices, this isn't a comprehensive listing of everything that is in the Act. If you do need a copy of the Act, I can send it to you because there are things I won't be discussing, such as calling within reasonable hours, among other things that we're pretty familiar with as it relates to the FDCPA, but I'm going to go with some main ones that have been talked about. So the first one is disclosure. The debt collector must disclose in communications with the debtor, written or oral, that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose. So this applies to all communication directly or indirectly to a debtor. It doesn't matter if you do it once or 100 times. If the act applies, you still have to keep doing it. So you'll see on those collection letters a lot of the times, you see that little verbiage at the bottom of the letter, and you see it on every single letter. You can't just do it once and think it clears you for the entire time. You have to do it on every letter. So now, verification. Within 5 days of the initial communication, so that is if it's a telephone call or whatever else it may be, it doesn't have to necessarily be a letter, you got to have the standard notices, which I'm sure again, most of us have seen. So you have to tell them the amount of the debt. It has to be accurate. It can't be an estimated amount. So if it's $500.69, you can't put $500 or $501. It has to state $500.61. You want the name of the creditor, a statement that if the consumer notifies the debt collector within 30 days that the debt is disputed, the debt collector will send verification of the debt or a copy of the judgment. And that's really because you got to be able to back up the debt. You can't just, people can't just send random letters saying a debt is owed. This is all about making sure that it's backed up with evidence. And then a statement that upon the consumer's written request within 30 days, the debt collector will provide the name and address of the original creditor. Something to note, if you don't do this within 30 days, that is a violation. So there is a laundry list in the Act on false and misleading representations that if you're concerned about this, but I think the primary one here is the threat to take action that cannot legally be taken or is not intended to be taken. So the usual example of this is if you know that the statute of limitation is going to run, or for whatever other procedural reason, you can't say you are going to sue the debtor. You can't do that. You can't say that because you legally can't. So the statute of limitations has run. You can't go and say, oh, we're going to sue you, because you can't. Another one is false representations or implication that documents are legal process. So if there's some kind of communication that's going to represent itself as a complaint being filed against you, or some kind of draft complaint that would technically be in violation, that would be in violation of that act. Now, a question did come up. I usually do questions at the end, but a question did come up pre-webinar. I got it yesterday about whether sending a draft lawsuit to a debtor with a message that the lawsuit will be filed if the debt is not paid, is that considered a threat and or violate the FDCPA? And that question and that is a good question, and the answer is it depends. So if you're not actually going to sue the debtor, then yes, it can be perceived and seen as a threat. And I've actually filed against creditors for doing that for this exact same threat. Versus if you're really going to sue and you've sued previously, then no, it's not going to be a violation. It's not going to be seen as a threat. So a good example of this is when you have creditors saying, well, you have $100 debt, which, any creditor does this. You have $100 debt and we're going to sue you. Are they going to sue you? No. I mean, there's no way. To file a complaint, at least in California, it's $435. They're not going to spend good money after bad. But for $1,000, which is a small amount still, yeah, you can sue. And if you have sued before and you plan on suing, then yes, that isn't going to be perceived as a threat. So, is contacting the debtor's attorney subject to the act? And I think this is a surprising answer to the question. A lot of people don't know that, yes, the FDCPA could apply even when speaking to the attorney. There's a big jurisdictional split on this, though. So one faction says, yes, communication is defined broadly and includes the conveying of information both directly and indirectly. So the key in this ruling that came down from Syed versus Wolfoff is that the act states the term indirectly. So communicating with an attorney indirectly goes towards the debt, so it would fall under the act. And that was their justification. But the other faction says no, which again, in my opinion, is far more reasonable. The act aims to protect unsophisticated debtors, and their attorneys act as an intermediary with the desired level of sophistication. And the court's saying here, attorneys are more sophisticated in the laws and what's going on. And so, no. Now, penalties and enforcements, what is the liability? Which is probably one of a very important topic to anyone listening here. You want to know, how does this affect me, my company, my firm, and why is it important? So there's actual damages, like I had to get a credit report, I made a payment I shouldn't have had to have made, I had to go get XYZ advice from someone that I had to pay. Those are actual damages. And then there's damages of $1,000. And this is punitive in nature. This is a strict liability statute. So the violation has to be committed just once, and then the damages are automatic. Now, the big kicker here is going to be the cost and attorney's fees. This is really where it can raise the amount by a lot. It is big because there's a case where the damages awarded to the debtor were $1,000, but attorney's fees can be $5,000, $10,000. And I will say that I've been awarded those attorney's fees in the past. For a one-time violation, you can get $6,000 to $10,000 in attorney's fees. So it winds up being a much bigger damages amount and penalty amount. So something to think about in subrogation cases is that you're not just going to be talking about one debtor, right? You're going to be talking about lots of debtors, 10 people, 100 people. You could talk about class actions. Now that we've gone through all of those definitions, which are very, very important, let's get to the meat of this presentation. Well, when would the FDCPA apply to the activities of a subrogation agent? Whether you're an insurance company or a third-party administrator, which I may reference in the future as a TPA, or even an attorney. So here's a seminal case in this area. It is Hawthorne versus Mac Adjustments Incorporated. Here was a two-person motor vehicle accident. Liberty Mutual was the auto insurer of the not at fault driver. They paid out the claim, and after that, they referred it to their TPA to go ahead and pursue subrogation against the at fault driver. Well, apparently Hawthorne didn't care much about that, and in order to skirt his obligations and to some degree, he decided to hire an attorney who thought it would be a clever idea to bring a claim under the FDCPA. So the court looked at this and said, well, this isn't going to apply here because we're not talking about the debt. If you're going to be have a debt collector, you have to have a debt. And in order to have a debt, you have to have a consumer transaction. So here at a minimum, a transaction has to be some kind of business dealing or other consensual obligation, more or less like a contract or some sort of sale. But here the adverse driver's obligation to pay money arose out of a tort, his negligent driving. So we're not talking about a consumer transaction. Therefore, it doesn't make sense to apply this act to this sort of thing. So from this came a lot of post-Hawthorne tort basis decisions. And on this screen, there's a number of cases that follow that reasoning for Hawthorne pretty much to a T. We have Shaw versus Credit Collection, the TPA subrogation claim against the driver liable for Allstate's loss sustained in the motor vehicle accident was based in tort, was not a debt. And again, they cited Hawthorne. You also had Antone versus State Farm, and that was an alleged negligent driver's FDCPA claim against State Farm for efforts to collect state court judgment debt, stated no cause of action because, again, the action arose from a tort claim. I think you guys kind of know where I'm going with this one. Taylor versus Javich Block and Rathbone. The TPA's pursuit of default judgment on subrogation tort lawsuit not governed by the FDCPA because no consumer transaction. Again, citing Hawthorne. Basically, what all these courts are saying is, look, if you're going after a third party, if you're going after someone, and you're alleging negligence, and this is where your subrogation claim is arising from. So if you're talking about a motor vehicle accident or a property loss like water damage for negligent plumbing, then you don't have to worry about the act because the doctrine is being pushed by the court today is that it is a tort, not a consumer transaction, so there's no debt, no FDCPA application. The big question is, and this is where the law gets murky, because it always does, and it gets scary for people who are working in the subrogation industry, because you'll see it is a little bit unreasonable and somewhat of a backward reasoning, while still turns out it is favorable. It leaves open the problem too many gaps for comfort. So in this case of Hamilton versus United Healthcare of Louisiana, you had a single vehicle motor accident. Hamilton, who was in the car, was injured very substantially, and his group health insurer, who his father had gotten through his employer, paid a large amount of medical expenses. And Hamilton filed an uninsured motorist and MedPay claims. And and this was basically in order to essentially double recoup for everything that had already been paid. So not surprisingly, right, the health plan asserted a lien on the proceeds and used the TPA in order to try to get the recovery. So the court looked at it and said, well, this could be a debt. And a matter of fact, we do think it is a debt. And the reason is that the father purchased the group health insurance, which I assume came through payroll deduction. They didn't say whether or not it was an ERISA plan, but for the purposes of this, it's not entirely dispositive. But the health insurance that is for personal, family, or household use. So we've got a transaction. It's for personal household use. It is for insurance. So they're saying this obligation to pay under the subrogation claim, whether you say it is a lien, whether it's an assignment, whatever you want to call it, it is part of the policy, part of this contract. So it's out of a consumer transaction. It arose the payment obligation. So we do think it is a debt, and the FDCPA can apply. But the court did not decide the other issue because it wasn't raised on appeal, which is the subrogated party a debt collector? So you can have a debt, but you may not have a debt collector. And in that case, if there isn't a debt collector, you're not going to have an application of the FDCPA. So this went back to the trial court, and the trial court looked at it and said, well, look, this is a debt according to the Court of Appeals. They have to follow that. But they look to the exception that we just discussed, which is, well, they're attempting to collect a debt, and they obtained a debt prior to the time it was in default. So what does this mean? What is default and what is obtaining the debt? Well, looking at this trial court, default, we think here, is based on the nature of the subrogation claim, the lien, the reimbursement. We think that the default occurred after the insured has received the settlement or judgment proceeds, and the debtor says, I'm not going to pay this back. And in this particular case, looking at the act, the court said the health plan sent this over to a TPA. Well prior to the time Hamilton actually received those settlement funds. And we're going to look to this exception and say the TPA is not a debt collector. And the health plan was included in this too, but I think they might have just been dismissed at some point or at some juncture. But that allowed the TPA to get out of the Act's application and not be held liable thereunder, which again is fairly good results. But the problem here is, does it lead to a pretty substantial gap where something could apply, and we're going to go over this later. Essentially, the question that remains is, what happens if you are a TPA or attorney and you get the debt after it settles? You know, if there is like a health insurer who is somebody who's trying to get recovery that was owed under their policy, and they said, hey, this guy isn't going to pay, they got their settlement, so we're going to send it over to somebody. Technically, the act could apply there. So there's a couple of pre-default cases that are very similar to this one. And to a large degree, there has not been any disruption of Hamilton. No one really seems to want to disrupt it. The good news is that there really hasn't been a case where the facts applied, so that is fairly reliable to look at, even though, again, as I said, there are a couple cracks in it. So if you look at Healy versus, and I'm going to butcher this name, Janus, the TPA was exempt from the debt collector status for purposes of the FDCPA, where the TPA obtained medical billing debt pre-default, even though the TPA was registered debt collector and included FDCPA verification language in letters to plaintiff. So, but even still, the court said that very well may be, but this is not dispositive because they got this debt and even had asserted it prior to the time there was any sort of recovery. So we're not going to apply the act here. Then you have Kesselman versus the Rawlings Company. So we've had a couple of ERISA plans. The ERISA question was not really raised. We can discuss that later. They were having their typical ERISA lien. They had a number of participants who had settlements coming. They are trying to get recovery owed to the plan under the plan's terms. But because, again, they got it prior to the time the parties actually settled the underlying case, there was no application of the act. And then you have another one, Danton versus the Rawlings Company. The FTC did not apply to a TPA subrogation recovery efforts against the insured where debt was obtained prior to default. So I just want to talk about another noteworthy exception. This is an earlier case that actually predates Hawthorne, which is the genesis of the entire subrogation and debt collection issue. So this is a Northern District of Illinois case where Allstate had paid out a claim to their insured and started to send out demand letters to the tortfeasor, the adverse driver. And it even contained that FDCPA verification language we had spoken about. And the court looked and said, well, this is your own personnel. And the argument on behalf of the plaintiff was that it is a separate subsidiary, a separate department. And I think we're pretty familiar with the fact that there's a lot of insurance groups that have a lot of different arms to them. So they try to say this isn't necessarily Allstate. This isn't the insurer, but this is Allstate's different subrogation people, and they're in a different state and in a different building. And the court didn't find that compelling. They said, no, this is an employee of the creditor, and we're not going to apply the act in this case. An interesting fact, the court did mention that while this claim against the third party is a debt and actually came to the contrary conclusion to Hawthorne, it could be a tort or a consumer transaction, but we think it is more arising out of a consumer transaction because they got I got right through the subrogation provision of the insurance policy. And now we are at our second polling question. When the claim is obtained prior to settlement of settlement, I should say, or judgment, I apologize, does the FDCPA apply? Yes or no? I'll give you guys a little time to answer. Okay, with about 80% of the vote in, the answer is no. So let me give you a basic overview of FDCPA and subrogation and kind of break down what is the real application of this in real time. So here I've attempted to put out a checklist. It might be an easier reference to go through and say, well, based on my position and my activities and who they're against and what time I'm doing them, you can go through and kind of give yourself a litmus test and say, should this be something I should be concerned about? So if you're an employee of the subrogated party, let's say maybe you are a plan administrator or someone within an ERISA plan or an in-house subrogation adjuster at an insurance company, or an auto insurer or health insurer, anything of that nature of that act. The act is not going to apply. It's not going to matter who it is against and what time you obtained or start doing it. It's just not going to apply. A TPA, by which we're talking about a separate company altogether, a separate entity, the act could apply. It might not necessarily be based on the other factors that we're talking about, but it certainly could. An attorney, we talked about that at length, but yes, the FDCPA could apply depending on other circumstances in the case. So then the next question is, well, who is my claim against? Well, we're talking about a third party, anybody who might be liable for a tort or also conversion or like construction claims. The act is not going to apply there, but you might have an exposure when you're going against the insured. This is mostly going to be an issue in health liens, might be less in property due to the anti-subrogation rule. So then the big question is, well, when was the debt obtained? When did you get the debt? It is not really an issue if you're a subrogee employee because you're covered anyway. But in addition to that, you didn't really obtain the debt because it was your company's debt all along. But for everyone else, if it was prior to the time you obtained the settlement or judgment, you don't need to worry about it. That shouldn't be an issue. But if it's afterwards, if it's after the time they got the money, and I could presume it was in the lawyer's trust account, just to be kind of safe, because there's not a real clear clarification of the default exception as expressed in Hamilton. But in that case, he had gotten the money, he had refused to pay, and whether there was different facts, maybe he got the money and didn't refuse to pay, they might distinguish based on that as to when it was dispersed or if the lawyer got it in its trust account, or maybe they got a check but didn't deposit it yet. I think there's many ways that this could go. So again, that's why there's some cracks. So this very well could be based on what future there is, because there's a lot of open territory on this. There's just simply not a lot of case law, and I just listed a lot of different fact scenarios that haven't been presented for discussion yet. So there is a lot to look forward to. So let's go through some examples. Ivan, I have some really fun names. Ivan insured is rear-ended by Tom Tortfeasor. His auto carrier, Acme Casualty, pays for the damage to Ivan's vehicle. After the claim is paid, Sally Subro sends several subrogation letters to Tom, demanding payment for the property damage. Are Sally's activities subject to the FDCPA? And the answer is no. Sally is an employee of Acme Casualty and therefore accepted from the definition of debt collector. Additionally, Acme's claims against Tom arose out of a tort, not a consumer transaction. So there is no debt. So definitely not a debt collector. Example 2. We have the same accident. He's rear-ended by Tom. As a result, though, he has soft tissue injuries requiring chiropractic treatments. Acme Casualty pays a chiropractic bill under its medical payment coverage. Ivan later files a claim against Tom's liability carrier and receives a generous settlement. Sally demands repayment of Acme's subrogation lien from the proceeds. Are her actions subject to the FDCPA? And the answer is no. Again, as an employee of Acme, she's not a debt collector. So she's still going to be exempt from the definition of debt collector. Let's go through example 3. Beneficiary has just eaten at his favorite ice cream parlor, Banana Splits, and on his way to the parking lot, he slips on a banana peel and breaks his leg. His health insurer, Group General, pays for a number of surgeries. Recognizing subrogation potential, Group General refers the claim to Reliable Recovery, it's a TPA. Reliable sends subrogation notices to Banana Splits, Ben, and Ben's attorney. Ben later receives a moderate settlement and refuses to pay the lien. Are Reliable Recovery's activities subject to the FDCPA? The answer, again, is no. Reliable obtained the debt prior to the default because they took over the subro efforts before Ben settled the claim. Hence, they are not a debt collector. So even the communication that would occur after that, that would still not be a debt collector by virtue of the exception of where you obtain the debt pre-default. You're not going to have the application of that act. So the same facts in this example for example number 4, but rather than referring the file to Reliable Recovery Group General, Group General pursues subro on its own prior to and throughout Ben's lawsuit. After settling with the adverse carrier, Ben still refuses to reimburse Group General. Needing some assistance, Group General retains Reliable Recovery, who contacts Ben to demand reimbursement. Are Reliable Recovery's activities now subject to the FDCPA? And the answer is yes, at least in theory. So it's based on logic that's out there right now. So Reliable, or whoever their adjuster is on this file, they're not an employee or officer of Group General. This is a consumer debt because we're not talking about tort liability. This is a consumer transaction because Ben paid for his health insurance out of pocket for him and his family. So this is personal or household family purposes, and they got the file after Ben received the settlement funds and then refused to pay them. So at this point, yes, the debt is in default. After that point, it went to a person, the defendant, and yeah, they do not get to enjoy that exception that will get them out of the application of the FDCPA. So they could conceivably have substantial liability. But there is to note that there is currently no case law with these particular facts, and no published decision to date has held a subrogation agent liable under the FDCPA. So it could very well go either way. The federal court could either say, look, hey, state, based on the law that we have in front of us, there is an FDCPA application and liability here. Then probably you could be looking at a very substantial attorney's fees. Or they could go the other way and say they're going to carve out something else for us, because there does seem to be a reluctance of the courts to apply the act of subrogation, which I think is reasonable and good. So let's look at some state-specific consumer protection. There's a number of jurisdictions that all have their own individual consumer protection acts or debt collection acts, and the problem with getting any sort of fabulous comprehensive answer to all of this is that they are all so different and courts treat them differently. Most of the time it comes down to statutory construction, and they all use different phrases like collection agency versus debt collector, consumer protection, or it could depend on a transaction, or it could not depend on a transaction. So let's take a look at our first 3 states, Texas, Florida, and Louisiana. In the subrogation industry, these states actually remain great. So in Texas, they have 2 decisions on this. In both of them, they looked at the exact same reasoning as in Hawthorne, and they said, no, we think this arose out of a tort. So we're not going to apply our own Debt Collection Practices Act. And if you look through those cases, actually, I believe one of them or both of them were against tortfeasors. They actually went beyond Hawthorne's reasoning and said, even though this is not a claim against a third party, this still arose from a tort. And quite frankly, if Hamilton had been decided that way, there might not be a need for this webinar, but we are here today. So in Florida, in Schaefer versus Seattle Service Bureau, the plaintiff had been in a motor vehicle accident while uninsured, causing property damage and bodily injury. State Farm paid its insured's claims and referred the subrogation matter to Seattle Service Bureau, who sent Schaefer several demand letters. So she filed suit alleging violations of the FDCPA, it's the Florida's Consumer Protection Act, as well as the Florida's Deceptive Unfair Practices Act. And the FDCPA directed the court to give weight to interpretations of the federal court and the FTC. Thus, the court applied the holding in Hawthorne versus Mac Adjustments, which we talked about, and found that a subrogated tort claim does not constitute a debt under the FDCPA because the third party's liability does not arise from a transaction. Then there's Louisiana. This again was an FDCPA case. They tried to make a state law claim, and they decided similarly that the claim arose out of a tort, not any kind of consumer trade practice, and that the Louisiana Uniform Trade Practices Act would apply to, so they declined to apply their state law. All right, now the beautiful state of California. It's a little bit more problematic. And really, when is California not? They always make it difficult in almost every area of subrogation. So in this case, there's a lot going on, and it's very convoluted. But the long story short is you have the TPA and auto insurers. They paid out uninsured motorist benefits, started sending demand letters, trying to recover on these third-party claims. Rather than actually recognizing tort liability to pay the claim and attempt to settle it, so they contacted an attorney who brought a suit under the California Business and Profession Code, section 17200. It's unfair competition. And the court looked at the statute and said, well, you can't have unfair competition or unfair trade practices. They wanted to know under these facts, with sending these demands and saying you're uninsured, we feel that you have tort liability and you owe us money. There were a lot of allegations of whether these communications were inappropriate, about the content being too threatening or perhaps a little too certain of the defendant's liability. So the court was looking at this and saying, is this unfair? And of course, the courts came up with a 3-pronged test. They looked at, 1, is the consumer injury must be substantial. 2, the injury must not be outweighed by any countervailing benefits to consumers or competition. And 3, the injury must be one that the consumers themselves could not reasonably have avoided. So looking at this case, Camacho did not dispute his liability. We're really not sure why. So the court said there's no violation of his rights. There is no injury because he never said he wasn't liable for that. So how could he be injured? And obviously there's a societal benefit of collecting sums owed by an uninsured motorist that outweighs any injury he thinks he might have suffered. And then lastly, the injury could have reasonably been avoided had he had insurance. So the practices were not unfair under the Act. Some things to note about this case, while the plaintiff alleged some violations of the California's FDCPA Act, it's again also known as the Rosenthal Act, the plaintiffs actually didn't bring a claim under the act. They didn't discuss extensively about this, but I can only assume it was a result of not great pleading there brought by the plaintiff. But for that reason, the court declined to make a decision as to whether there is any liability under the act. So this is still out in the open. Interestingly enough, there was a position taken by the California Attorney General in this case. He filed an amicus brief in this case, and he argued that yes, the subrogated defendants should be liable. We want to apply our Consumer Protection Act and the debt collection law to subrogation. Thankfully, the court disagreed with them. And another interesting thing about this case is they made no distinction between tort and contract basis. That really was not a relevant inquiry for this court. And we are now on our final polling question. In the Texas, Louisiana, and Florida cases discussed, the FDCPA did not apply. True or false? All right, with about 85% of the vote in, the answer is true. So let's go over to Colorado. This is a bit of an interesting situation because there's an informal staff advisory opinion from the Colorado Administrator of the Collection Agency Board. They're a subdivision of the Attorney General's office. And it specifically actually discussed Hawthorne and Hamilton. It really didn't care for Hawthorne's reasoning. They said it was a little bad, and they said, well, our act is broader than the FDCPA. Our reasoning is a little different. We think that the tort even could be a transaction, and that's a little odd. But the major bullet point here is that the AG office said, we think our Debt Collection Practices Act applies. So if there are any applicable requirements under this act for the subrogation people who are doing subrogation in Colorado, it's something to think about because according to them, you have to register as a debt collector or comply with their act. Interesting thing, though, is that in spite of the Attorney General's opinion, of which it seems to me that quite a few people might know this in the industry, there actually doesn't appear to be any case law in Colorado that specifically addresses the subrogation claim being punished under the act. The way that the tide seems to be turning with a lot of insureds and attorneys trying to find new and novel ways to dishonor our subrogation liens, you probably should be expecting some of this coming down the pipeline. Now let's talk about Hawaii. Of course, they had the horrible events in Maui in the past month. But this particular case we're talking about is actually semi-famous in the area. So it's Flores versus Rawlings Company, and the holding is that a TPA working on health liens, and I can't say whether or not this would apply against a third-party claims against tortfeasors or not, as far as trying to pursue subrogation liens against an insured. Well, you got to register as a collection agency. It's distinguishable from debt collectors, though, under their statutes, but you're going to still have to register as a debt collection agency. So something to note is that the reasoning, it seems like they had to stretch a little bit in order to make it work. And what happened there was that the subrogation carrier made the insured sign a loan agreement after receiving treatment at the hospital. And they were saying, we are paying this, so we're essentially loaning you this money, and you got to pay us back if you get a third-party recovery. And the court here said, well, we think this is a consumer transaction, and therefore the collection agency law should apply. And they found that there was no injury to the plaintiff, despite the fact that they had to engage an attorney, that they maybe did a credit check or something like that. They just said that the way our act works here, we don't have a cognizable injury to enforce. So essentially, even though the TPA should have registered and didn't, enforcement of this is really in the hands of the Attorney General and other consumer protection people in the Hawaii state government. And there was no other violation other than the fact that they just didn't register. So So let's talk about Washington. This really is the most problematic state insofar as state consumer protection law is concerned. There were dual cases that were decided together. So you have some tortfeasors, third parties, and insurers at first, and the insurers at first sent them some demand letters that were a bit more reasonable, saying that we think you have tort liability, you should pay us. And then they sent it over to their TPA, who was sending much more aggressive demands. And they were styled as collection notices. They were displaying increasing urgency, saying this is going to be reported on your credit. You're going to be sued under a debt more than a tort. So they looked at their Consumer Protection Act, which outlaws unfair and deceptive acts or practices in the conduct of any trade or commerce. And there's a much broader, and they have a much broader statute than the FDCPA. So what they looked at was this unfair and unfair or deceptive, and actually they distinguished from unfair. They thought that styling them as collection notices was deceptive, and they said you don't need to have any privity requirement, i.e. a transaction or some sort of other relationship of that nature. They said as long as you are doing any sort of services that have a direct or indirect effect on anyone in the state of Washington, the act can apply to you. And the injury requirement they looked at, again, very liberally. They didn't want to set a high bar for that. And they said even if you have to procure a credit report, the act is going to apply. And this is a little funny because the court even recognized we know that the FTC doesn't apply. We know the Washington Collection Agency Act doesn't apply to subrogation. We know our insurance codes don't apply to subrogation recovery, but we're going to use the Consumer Protection Act as something as a gap filler, essentially, because the court felt like something ought to apply. So this went up to appeal to the Washington Supreme Court, and on appeal there was some argument that, well, you should be able to have a certain level of different kind of communications if you're talking about a tort adversary, essentially the third party exception, and you can't treat them like consumers or general debtors. It is interesting because the Supreme Court said, well, it is deceptive because consumers think that the FDCPA and Collection Agency Act, and to some degree the insurance code, they think it's going to protect them. And it won't. So these activities that people think incorrectly would fall under that, well, that's deceptive. So we're going to apply it because people think other stuff will apply, which is not very sound reasoning. There's also this New Jersey case, CASME versus CCS Commercial. It's a federal district court. The decision represented a new offensive in an effort of trial attorneys to hold us subrogation professionals liable. So CCS Commercial sent 2 letters to the plaintiff seeking payment of a subrogation claim arising out of a motor vehicle accident. And then CASME informed Progressive that he was not involved in the accident, did not own the vehicle. Progressive instructed CCS to close its file, and CCS sent CASME a letter to inform him that it was doing so. And they included language at the end of the letter, though, that said, even though this matter is closed, this office is still required by law to make the following statement, that any and all written communications, that this is an attempt to collect a debt. So, CASME filed a suit alleging that CCS violated FDCPA by sending him the letters without validation notices that were required by the FDCPA. So, CCS did remove this action to federal court, and the court was relying on longstanding 11th Circuit precedent, which was Hawthorne versus Mac adjustment. They argued that the subrogation claim is not a debt. They alleged the obligation to pay did not arise out of a transaction, but rather arose out of a tort. So FDCPA doesn't apply. But CASME, he was clever. He pounced on the language of CCS's closing letter to establish that the FDCPA did apply. And that basically that was an admission that they were a debt collector. But CCS did do a motion for judgment on the pleadings, and it was granted. And in keeping with prevailing law, the court recognized that there must be a debt for the FDCPA to be applicable, which must rise out of a transaction. So the next couple slides I have, because I know we are running out of time, are just kind of a summary of state court holdings that we talked about. We have Texas, Florida, Louisiana, California here. I also have here the summaries of Colorado, Hawaii, and Washington. So just quickly, some potential issues and problems, just some things to note. Workers' compensation. So would this apply to workers' comp, even if you're talking about a TPA or an attorney who's trying to pursue somebody on behalf of either a comp carrier or an employer directly? It depends on the state you are in, but typically they're going to be statutory liens. So there's going to be a statutory right of subrogation. So on that note, there's a good chance that you could find, well, that this is not necessarily a transaction. It's not arising out of a policy that a debtor would have with a creditor. Additionally, those premiums are paid by the employer typically, so the insured employee has not bought anything. So there's a very good argument that the act wouldn't apply there. You also have ERISA. I don't think that's much of an issue insofar as the FDCPA is concerned. But then just some practical aspects of the FDCPA application. One of the things about the FDCPA is if you're going to file suit against the debtor, you got to either do it where they signed the written contract for the obligation or where they resided. And so if you think about this, let's just say somebody bought insurance for their vehicle and resides in some county in California, but gets in an accident in Nevada, and they sue the other party in Nevada, and presumably there's an enforcement in the subrogation lien. The question is, can you bring this claim in Nevada if the act is going to apply? Can you pursue the debtor or sue them or intervene or have any sort of action in that separate venue? That's kind of an open question. So that is the end of my presentation. We do have a book. It's ERISA and Health Insurance Subrogation, and it's for all 50 states, and it does actually have a large chapter about FDCPA acts. It's a wonderful resource, and it's available through our Juris Publication website as well as on our website. I know we covered a lot of information in a short amount of time. I wish I had time for questions. I unfortunately do not, but we do have them all, and I will answer them as quickly as I can in the next couple days. I thank you again so much for attending, and I hope you enjoyed.